All right, so the case that we are going to hear this week is cause number 23 DCCR 0944, and it's styled the State of Texas versus Michael Keith Brasher Jr., charged by indictment with the offense of aggravated assault against a public servant. And you guys, I don't have my indictment in front of me. Is it first or second?
It's first.
The punishment range for that offense is a minimum of 5 years in prison, up to 99 years or life in prison, and or a fine of up to $10,000. So that's obviously a very large range of punishment. We'll talk more about that in a few minutes also. We don't anticipate this trial to last longer than a few days this week. We don't anticipate it going into next week. I'm going to introduce to you all everyone that's here. And then I'm going to ask you all if any of you know any of us. Just because you know someone that's involved in the trial does not mean that you can't serve as a juror. We just need to know who you know, kind of how you know us, and then if you think that that relationship would cause you an issue in being able to be fair in this trial. So representing the state of Texas, we have Assistant District Attorney Tommy Coleman.
Good afternoon.
And Assistant District Attorney Kobe Hoffpower.
Good afternoon.
And then representing the defense, we have Mr. Ryan Matuska.
Good afternoon, yeah.
And the defendant, Mr. Michael Brasher. And then you'll see to my far left, again, Ms. Tanner, the court reporter. An important thing about her is that she's not just taking down what I say or what the attorneys say, but she's also taking down what you all say. And I know that public speaking isn't everyone's favorite thing to do, but we are going to ask you during this process, if you're speaking, to please speak loudly and clearly so we can all hear you. We'll also call you by your name and your juror number. That way the record is clear as possible as to who's talking at what time. If you have an answer to a question or something to talk about that you are uncomfortable talking about in front of 50 or so of your new best friends, all you have to do is say so. And what we'll do at the end of this process is we'll take a break and have all of you exit the courtroom. And if there's something you want to talk to us about privately, we'll bring you back in one at a time. We do that in every trial. Sometimes we do it because you want to come visit with us. Sometimes the lawyers want to visit with you a little bit more. What we don't want to happen is for you to have some kind of information that you're thinking, you know, they didn't ask this question. It might be important. I'm not sure. We want you to tell us that. And at the end of this process, I will actually give you an opportunity to let us know if there's something you want to talk about. We don't want you to end up on the jury and you're sitting up here and we're a couple of days into trial and then you say, I should have said something. I can't do this. Potentially what that could mean is that we would have to start all over and go through this process again, and obviously we don't want to have to do that. So this process, we try to make it informal, we try to make it comfortable for you to speak. I will and try and probably fail at some bad jokes. We and the attorneys may do the same. We don't want you to at any time to think that we don't think what we're doing here is important or serious. Everything we do here are felony criminal offenses, so it's all very serious. But the whole purpose of this afternoon is for you guys to kind of loosen up, visit with the attorneys so they can get to know you. We oftentimes call this jury selection, and it's really not a selection process. The attorneys don't get to say, I want this one, this one, this one, and this one, and that's not how we do it. So what happens is they get to know you, and for any number of reasons, they have 10 strikes. So they can strike people off for just about any reason. There's some exceptions to that. And then it's really the next 12, and then we'll have the alternate 13 that start from number 1 on. And so it's really kind of a deselection process. So it is important that you talk to them, let them get to know you so that they know what to do when it gets that time this afternoon with regard to their selection process or deselection process. I'm going to go through now and go again row by row and ask by a show of hands if any of you know any of us. And so starting on the first row, yes ma'am, we've got number 1, Miss Nobles. And who do you know, ma'am?
You.
And how do you know me?
Our sons went to high school and junior high together.
They did. And is there anything about that that would make you feel like you couldn't be fair in this case?
No, ma'am.
Thank you, ma'am. Anyone else on the front row on this side? Let's go across front row over here. Anybody know any of us? All right, second row then. Coming across second row coming this way. Yes, sir, you are, let's see, is it number 28, Mr. Tanner? Can you answer out loud?
Yes, that is correct.
Thank you, sir. That's just for the court reporter and us. And who do you know, Mr. Tanner?
The court reporter.
Miss Tanner?
My niece.
And how do you know Miss Tanner?
She's my niece, married by my nephew.
Is there anything about that relationship that would make you feel like you could not be fair in this case?
No, ma'am.
Thank you, sir. Third row on this side. Yes, ma'am. Is it number 29, Miss Hinton?
Yes, ma'am.
And who do you know, ma'am?
Attorney Matuka from juvenile probation.
Okay, how are you?
I'm good.
Is there anything about that would make you feel like you could not be fair in this case?
No, ma'am.
Thank you, Miss Hinton. Anyone else? Third row coming across that way. Third row over on this side. Let's go to the back row, coming across all the way on the back row. All right, see, it's not that hard. Easy questions. So I'm going to go through with you guys just some general housekeeping matters, and then I'm going to go through some general legal principles that apply in every single case. Then I'm going to hand it over to the attorneys and stop talking. Again, the only thing that really is important this afternoon is that you tell the truth. That's the only oath you've taken. What we don't want you to do is try to answer a question in the way you think we want or the attorneys want you to. They really want to know what your thoughts are about the law and things like that. It can be frustrating this afternoon in this process because the lawyers are not allowed to discuss with you the particular facts of this case. And so they're going to be asking you questions in general or kind of, generalities and things like that. And so I don't want you to get frustrated with them and think your answer typically would be, I don't know. I don't have enough information. You didn't tell me about the case. They're not doing that on purpose to make you upset or frustrate you. They're not allowed to talk about the specific facts. That happens later when we have witnesses that are sworn to tell the truth. So they're not going to get into that right now. They're going to talk about type of cases, punishment, things like that. And so kind of just be open-minded when they're asking you those questions and understand that that's what they're limited to. Our trials here in criminal court take place in two phases potentially. The first phase of our trials is the guilt-innocence phase. And then if there is a finding of guilt, the jury or the judge assesses punishment. And it is the election or the choice of the defendant as to who punishes him if he's found guilty. In this case, the defendant has elected, if he is found guilty, that the jury would assess punishment. And so I will talk a little more about punishment, and the lawyers will talk a little more about that, because that will become your job if the defendant is found guilty at trial. You do not have to have any kind of special knowledge or have been on a jury before to be qualified to be on a jury here in felony court. You will get at the end of the trial what's something called the court's charge, which is actually a written document that I provide to you that contains everything you need to put together with the evidence in order to reach a verdict. It will have instructions, the law, definitions, everything you need, so you don't need to have any extra information. In fact, if you're on the jury, you'll be instructed not to try to get other information. We don't want you Googling things or trying to figure out the law or anything about the case. It's very important that what you base your decision on comes only from here in the courtroom. Let's see. Again, it's going to be important that you speak loudly and clearly. Again, we'll call you by your name and your juror number so that the court reporter can take everything down that everyone's saying. I'm going to now talk just briefly about some legal principles that apply in every single criminal case. The first of those is the presumption of innocence. Our law provides that all persons are presumed innocent and that no person may be convicted of an offense unless each and every element of that offense is proved beyond a reasonable doubt. The law does not require the defendant to prove himself innocent or to produce any evidence at all, The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt. So if you were asked to vote right now whether or not the defendant is guilty or not guilty, what would your vote be? Okay, see, it's easy. So the state has the burden of proving the defendant, proving the defendant guilty by proving each and every element of the offense beyond a reasonable doubt. And if the state fails to do that, then you must find the defendant not guilty. I have used the term beyond a reasonable doubt now several times. And many years ago, there was an actual definition that was given to jurors as to what that meant. The highest courts in the state of Texas, however, have abolished that rule and no longer allow us to define that for you. I think that means two things. I think first, you decide for yourself what beyond a reasonable doubt means. And then second, you decide if the state has proved each and every element of the offense beyond a reasonable doubt. I'm sure the attorneys will talk to you about that more, but ultimately that is your decision on what that means and if they have reached that burden. Our law provides that a defendant may testify on their own behalf, but that same law, as you all know, provides that if a defendant elects not to testify, you cannot use that against him. And you can't talk about it. You can't talk about with other jurors about what he might have said, why he didn't take the stand. You cannot infer guilt from that. That's everyone's right. We all have the Fifth Amendment right not to testify against ourselves. And there are many, many reasons why a defendant would elect not to testify. They typically get advice from their attorney after the state has put on their case. Not everyone, as you all know, are good speakers, and there's just an abundance of reasons why. Human nature tells us we'd love to hear from whoever's charged with the offense. The requirement, though, to be on the jury is that even if you would like to hear from them, that you wouldn't infer that they're guilty just because they didn't testify. So that's also very important. Just briefly, I'm going to go back before I turn it over to the attorneys to that range of punishment, because I threw all that at you kind of quick when I got started, what the charge was, what the range of punishment is. The range of punishment for this offense is actually the most broad range of punishment that we have here in Texas. It's from a minimum of 5 up to potentially the rest of your life in prison. All of that is with the possibility of parole, but still it's a huge range. And there's many reasons for that, and mostly it's because every single case is different. Every allegation is different. Every defendant is different. Their circumstances, every victim or complaining witness is different. And so it can be difficult to understand or be able to say that I could consider that entire range. But what we need from our jurors is to be open-minded, say that you can listen to the evidence in that first phase of the trial. And if there is a finding of guilt, that you could listen to any additional evidence, good or bad or whatever, in the punishment phase, and then talk to the other jurors, deliberate, and consider the entire punishment range. Without knowing anything today, that's what we need you to be able to do, is say, you know what, I can consider the low end all the way to the high end because I don't know anything about the case or the circumstances. The lawyers will probably talk to you more about that as well. And if there's some reason you cannot do that, we obviously need to know about that also. The last thing I'm going to tell you, and this is all, again, probably a terrible attempt to loosen everybody up, but it's also true. A lot of times people think that if they're really quiet and they kind of sink in their chairs and they don't say anything this afternoon, that they're going to get to go home and not have to come back tomorrow. It is usually the opposite. It's usually the quiet ones that get to spend a few days with us. Not always, but sometimes. Again, that's hopefully to encourage you to be open, talk with the attorneys, and again, please don't hesitate. If there's a question that's asked that you need to talk to us in private, just let them know that. I'm going to be making notations up here, and we'll get you back in private at the appropriate time. All right, Mr. Coleman, you may proceed.
Thank you, Your Honor. Good afternoon again. My name is Tommy Coleman. I'm one of the assistant district attorneys
here in Jefferson County on behalf of your elected District Attorney Keith Gibbon and the victims in this case. I want to thank you for your time and thank you for your attention. If for whatever reason you folks in the back can't hear me, just please raise your hand and just let me know, and I'll do my best to speak up louder. I feel like sometimes I'm just yelling at these poor folks in the front row, trying to project these guys there in the back. What I used to do is apologize for the inconvenience, for the intrusion on your day-to-day life that coming down here and serving or potentially serving as a juror does to your day-to-day life, that interruption to your day-to-day life. I don't apologize for that anymore because this is important. It's important to our office, important to our community. It is definitely important to this defendant. I know for me, if I were sitting in this defendant's shoes, and I suspect it's the same for you, that if I were sitting at this table, I would want 55 or so people to give their undivided attention to this case and the issues, and to listen to the presentations of the attorneys without thinking about the work that are not getting done or the to-do list that they can be getting done and those kinds of things. So I don't apologize for the intrusion into your life, but what I will do is I'll make you a deal. If you engage me in a back and forth discussion and give me your honest opinion about the issues or what I believe the issues will be in this case, then I will not waste 1 minute of your time. In fact, I'll do my very best to keep it closer to 35 or 40 minutes as far as my presentation or my questions to you. So if I have that understanding, if I have that agreement, please raise your hand to let me know that we're all on the same page. I appreciate that. It looks like everybody raised their hand. For the record, I'm not talking to myself. The judge alluded to it before. Yeah, the fact that Ms. Tanner's taking down everything that is going on and being said here. So if, for instance, no one raises their hand, I may make a comment just so that it's on the record. I have read your jury questionnaires. I know a little bit about each and every one of you. Ms. Nobles, you're a financial planner, correct? Ms. Juror number 17. And by the way, if I mispronounce any of your names, just let me know, please. You're a teacher, right? And Mr. Tanner, juror number 28, process operator. And let's see, let me get one more here. 39, Rivette, where are you? You're a paramedic. So I say that to say I know a little bit about each and every one of you. So I think it's only fair that I tell you a little bit about myself. But for the time that I spent in the United States Army, I've lived in Texas all my life. Grew up in Dallas. I went to college at Texas Wesleyan University in Fort Worth. In law school at South Texas College of Law. For the majority of my career, I've been a prosecutor in some form or fashion, even serving as a federal assistant United States attorney for a while. I enjoy being a prosecutor, but contrary to what some people common belief may be, being a prosecutor is not just about seeking convictions. It's not just about sending people to prison. It, by statute, is about getting justice or seeking justice. And that's what I want for this defendant in this case. That's what I want for the community in this case, and that's what I want for the victim or victims in this case. And I've mentioned the victim or victims at least 2 or 3 times so far. I don't want them I don't want anyone to lose sight of the fact that there are real victims involved in the cases that we handle. Oftentimes, when we get to this point, the focus is on the rights, and rightfully so, the rights of the defendant, to be presumed innocent, not to testify, have all of the witnesses start out on the same playing field. All of those things are important rights for the defendant, but make no mistake, the victims have rights as well. The victims have a right to believe that they will be treated fairly and that justice will be proportionate to the wrong or wrongs that they've suffered. Would you agree with me, jury number 21, Mr. Richmond? Yes, sir. They have rights as well. I just want to make sure that we don't lose sight of those rights during this process. Now, we talked about seeking justice. Well, how do we do that? How do we get there? We get there by selecting 12 of you who will who will listen to the evidence in this case, the facts in this case, and who will render a verdict based solely on that evidence in this case, what we call being unbiased. Bias, sometimes the word, the term, it has a negative connotation, but we're all biased to a certain degree. I mean, Ford versus Chevy, Coke versus Pepsi, we have our own preferences or quote unquote biases. And I want to find out what, if any, biases you may have. I mean, the judge used the classic example of your home being burglarized, but Mr. Medina, I like to use the example of what's your favorite pie, I mean, what is the state pie? Anybody, just shout it out. What's the official state pie of the state of Texas? Pecan. There you go. And if this were a trial about what the best pie is, and if you knew that perhaps I have a preference for pecan pie, maybe even Mr. Hoffmeyer here has like pecan pie. If I asked you, Miss Castillo Rodriguez, what your favorite pie would be, the last thing I want you to do is say pecan pie because you think I like it, or you think it's the official pie of Texas. So a good Texan should like pecan pie. That's the last thing I want you to do. I use that example, Mr. Medina, as it's kind of a silly example. And the judge alluded to that. Sometimes we kind of use humor to drive home a point here. But my point is, if I want you to be honest, give the answer that you honestly believe, not what you think we want to hear, okay? So with that long lead up, what is your favorite pie, Mr. Medina?
I love pecan pie.
You say not?
I love it.
You love it? Yeah, there you go. A true Texan. But no, I'm on the teasing. Seriously, if there is an issue about any of the facts or the law, well, I shouldn't say facts, because you're not going to hear about the facts during this jury selection process. But any of the issues or potential issues in this case, or the law in this case, I want to hear from you. You can follow me, juror number 19, Ms. Rushing?
Yes.
All right. Ms. Rushing, you didn't list a job or anything on your questionnaire. What did you do, or what have you done in the past at World War?
Traveling spouse.
Traveling spouse, military?
No,
Okay.
big oil.
Okay, cool. All right, thank you very much. So, again, while I can't talk about the actual facts of the case, I can say that the defendant in this case is charged with aggravated assault against a peace officer or police officer. Or I should say, aggravated assault against a public servant. And that public servant in this case just happens to be a peace officer, okay? To understand the law as it relates to aggravated assault against a public servant, you first must understand, juror number 16, Mr. Ho, what aggravated assault is, okay? Aggravated assault is the reckless, knowing or reckless causing of bodily injury to another by using a deadly weapon. If you cause bodily injury to another person and you use a deadly weapon to do so, that is aggravated assault. Now, another way, are we clear on that, Mr. Ho? No questions? Okay, speak up, I'm taking out your responses. So, yes, you clear? Clear as mud? Juror number 22, another way, Mr. Durham, that a person can commit an aggravated assault is to threaten bodily injury to another by the use of a deadly weapon, okay? But if, for instance, if I've got a crowbar and I say, I heard you don't like pecan pie, Mr. Durham, meet me outside the parking lot, that's a threat, and I've threatened you with that crowbar, and that threat constitutes an aggravated assault with the deadly weapon, the crowbar. You follow me on that, Mr. Durham? Is there anyone here, raise your hand, who is unclear about the two ways that you can commit an aggravated assault, either by actually causing bodily injury with a deadly weapon or by threatening bodily injury with a deadly weapon? Ms. Brown, juror number 12, you clear on that?
Yes, sir.
All right, very good. Anybody not clear on those two ways? So that's the aggravated assault portion of it. Aggravated assault on a public servant. Well, you may say, well, who's a public servant? Well, a public servant, according to the law, is anyone who is, so I want to read it so I'll make sure we get it right, who is exercising an official power or performance of an official duty as a public servant, and that public servant includes someone employed as an officer or an agent of the government. That is that definition includes Ms. Albritton, juror number 8, a peace officer. You listed, Ms. Albritton, on your jury questionnaire that one of your hobbies is skiing. Would you like to go ski? Just curious. I've done it twice in my life. I managed not to get a tree out of ski. So a peace officer is a public servant for purposes of aggravated assault on a public servant. Why does it matter? Well, it matters because it bumps up the punishment range. Juror number 3, Ms. Flanagan, in a garden variety ordinary aggravated assault is a felony that's punishable by anywhere from 2 years in prison up to 20 years in prison, what we call a second-degree felony. If you commit that same aggravated assault against a peace officer, it is no longer a second-degree felony. It becomes a first-degree felony, punishable by anywhere from 5 years up to 99 years in prison. Okay? Punishment range gets increased significant. Why is that? Why do you think the legislature chose to do that?
I mean, they're out there protecting and serving the public, and if they get injured, that's like the worst to me. I feel like that would be a step up on their punishment.
Well said. I mean, if someone will assault a peace officer, what about you and me, just an average citizen? Well said, Mr. Flanagan. How long have you worked for the city of Beaumont?
10.5 years.
Ms. Prince, juror number 6, what makes police officers so special? I think Ms. Flanagan kind of stole my thunder on the next question, but wow, we'll bump it up that much for police officers? It's their job, right?
It's their job, and I think they've been sworn in to do a job to protect the public.
Should they expect some things or bad things should happen if they're out there doing their job?
Yeah, they should expect it.
Should they expect to be assaulted, or should they be subject to threats of bodily harm? Should that just come with the territory?
I think it does come with the territory.
And so if somebody assaults you, it shouldn't be a crime, or at least it shouldn't be an enhanced crime. This is one of those things. One of these things I want you to be honest with me.
That should be a crime.
Should be a crime, but what about enhancing the punishment? Significantly enhancing the punishment. I see you're struggling with it, Ms. Prince. I'll circle back to you. Ms. Edwards, juror number 11. Where is Call, Texas? Where is that?
It's up toward Jasper.
Really? I've never heard of Call, Texas.
If you pass by, you go down Highway 96,
If you're not paying attention,
you'll miss it.
all right. What do you think about this? Police officers, what makes them so special? Why do they get this? Why do they get the big punishment range, the big hammer of anywhere from 5 to 99 years?
Because they have the red mark on their back.
Yeah.
I think we all should all be held accountable, and we should all have the same, thing, if something happened to you, the person should be punished. But they seem like they're more out there more than we are.
You mentioned a couple things. One, they have the red mark on their back. I take that to mean, my interpretation is they got bullseye on their back. And I don't want to get too deep into it. I've opened this can of worms up before. And I don't want to spend the rest of my time talking about this because I've got a number of things I need to get to. But this whole sentiment out there nowadays of defund, or what's the other, I can't remember the other term, defund the police and whatever else what you're talking about. There's a sentiment out there. Law enforcement's not held to the same esteem level that they used to be. Mr. Clark, juror number 27, would you agree with me? Yeah. I mean, what are your thoughts on that as far as the regard or lack thereof for law enforcement and their authority? What are your thoughts on it?
Well, they are there to protect us.
And if they aren't there, who's going to do it?
Right.
Yeah. All right, this is kind of an important question here, so I want to kind of go row by row. Here on the first row, on this side, law enforcement, the respect for law enforcement. Well, let me not even talk about respect. Is there anyone here who has an issue with that enhanced punishment range. In other words, higher punishment for assaulting or committing aggravated assault against a police officer. Does anybody struggle with that? Does anybody have a problem with that? I just want to see if raise hands. All right, first row over here. Does anybody have a problem with it? Well, they should just have the same punishment range like everybody else. Anybody on the second row on this side? Anybody on this side on the second row? Third row on this side. You're okay with that? The legislature set this thing up, and you go out there, and juror number 34, Mr. Wright,
Yes.
work for Union Pacific. Anybody that does that kind of thing, should they be subjected to a higher punishment range?
I mean, they put the life on the line for us.
Anybody on this side of the third room who has a problem, any issue, heartburn? Remember, this is that time. I want complete honesty. I don't need you to tell me what you think I want to hear, but what you really believe. Anybody on the last row back here who may have some issues with the fact that police officers have that higher punishment? All right, so no hands have been raised. Juror number 6, Ms. Prince, I circle back to you. Will you give us some more talk? Anything you want to add?
I just think there should always be a mutual respect between the law officers, you know, so.
Fair enough.
I don't have a struggle with it, I just.
Fair enough.
there should be mutual respect.
Yes, ma'am. All right, so if there's nothing else on that issue, then I'm gonna move on. All right. Let's see. Proof beyond a reasonable doubt. That's how we get, that's the standards by which the state is required to prove its case beyond a reasonable doubt. The judge alluded to it. There is no definition of beyond a reasonable doubt. I like to think of it, and this is just me, juror number 24, Ms. Lyon, is you know it when you see it, it's in your head, in your heart, in your gut. If you believe there's enough evidence there and that whatever doubt you may have is not a reasonable doubt, then that's kind of my way of looking at it. Another way of looking at it, juror number 8, who am I not calling out? 17, Mr. Pretty. Another way to look at it is if you can envision one of those jigsaw puzzles, and you've got enough of those pieces of the jigsaw puzzle to figure out what that jigsaw puzzle is, what it represents. You may want all of those pieces of the puzzle, but if you've got enough there to figure it out beyond a doubt, beyond a reasonable doubt, that's the way I like to look at it, is if there is enough there for you to figure it out, okay? But what it's not the law does not require me, juror number 25, Ms. Hodges, to prove my case beyond all doubt, beyond to a reasonable degree of certainty. You understand that? You understand the law understands that there's only one way for you to know with 100% certainty if something happened, right? Am I talking to the right one? I see you're totally confused, Ms. White. You're like, why are you calling me Ms. Hodges? And I'm looking at you, you're looking at what? All right, so 25, Ms. Hodges, same question for you. What's the only way for you to know with 100% certainty that something happened? See it. See it with your own eyes.
Especially with police and everybody.
Yeah.
So that would be nice to see exactly.
And body cams are nice, but there was a time, believe it or not, where there was no body cam. And, you know, believe it or not,
She said it's kind of hard for me. I like to know for a fact that.
yeah, and I get that. And we'll, let me button up this one point first about the beyond a reasonable doubt, and then we'll talk about the types of evidence that we prefer to see. But you follow me that the law doesn't require that if you know by being an eyewitness that you would not be a juror, you would be on my witness list. You'd be somebody that I would call as a witness because you saw it with your own 2 eyes. The law recognizes that the law does not require me to prove my case with 100% certainty. Okay? Now, back to your issue with body cams, there was a time when there was not patrol car video, when there was not body worn camera video, when there wasn't a Ring doorbell camera on just about every corner. And we put on our cases, we put on evidence, put on witnesses, and jurors either believed those witnesses or they didn't believe those witnesses. Jurors either convicted or didn't convict based on that witness testimony. So there was a time, and there still are instances in cases where there is no video, okay? You bring me to a great point there, Ms. Hodges. Now I'll ask Ms. White this. Seriously, really, for you. I mean, could you base your verdict on the testimony of a witness? If you believe that witness, like we talked about, beyond a reasonable doubt?
Yes.
In fact, jurors and juries across the country, day in and day out, make that determination from speeding ticket trials all the way up to murder trials based on witness testimony. Either you believe the witness, you find that witness credible, or you don't. Okay? I'm not saying that there won't be video in this case. All I'm saying is that while video is nice, it very well, Mr. Pretty, be like one of those pieces in that jigsaw puzzle we talked about that you would like to have, but if you believe the evidence and you believe the witnesses, it's not necessary for you to come to that conclusion beyond a reasonable doubt. This is an important question. I'm running out of time, so I'm going to kind of run through this row by row. Is there anybody on this first row, given what we just said, would require me to prove my case with 100% certainty? That you would need DNA evidence like you see on TV. You would need 12 nuns to come in and testify and say, I saw that happen there. You know, we need satellite photos. You know, those TV shows, those crime shows really set the bar kind of high for us prosecutors. Anybody on this first row who would need for me to prove my case with 100% certainty? You could get there if you feel it in your head, in your heart, in your gut, that you heard enough evidence. Okay. Anybody on the second row who would require me to prove my case with 100% certainty? Anybody in the third row back there? And last row back there, fourth row, with 100% certainty. Mr. Hampton, you're number 54. I just wanted to call on you. I don't know. What do you think so far? Any thoughts? All right, fair enough. All right, so moving on. Is there a problem with gun violence here in Jefferson County? Jury number 5, Mr. Crane.
Jefferson County?
Yeah.
Everywhere, yes.
Well, but we live and work here in Jefferson County. I'm talking about Jefferson County specifically. Do you feel like there's a problem with gun violence? I heard some yeses over here. Do you feel like there's a problem with gun violence here?
I mean, nothing has affected me personally, but, I mean, I would say, yeah, there is.
It ain't the gun, it's the people who said that. Yeah, Mr. Coleman, no relation, right? Jury number 23. Self-employed there. It ain't the gun, it's the people. Yeah. Well, do you think we have a problem with the people using the guns? All right. We don't have enough time for me to talk about what the problem is or what the solution to that problem is. But is there anybody here who doesn't think that there's a problem with the people using the guns here in Jefferson County? All right. One really quick question. I'm going to run through this real quickly. Again, given the problem with the guns, how would you rate law enforcement's response to the problem of gun violence here in Jefferson County on a scale of 1 to 10? And invariably, two things. Invariably, I get somebody who says, well, I haven't done a study. I don't know the statistics on this. I'm just asking about your gut reaction of law enforcement's efforts or actions to try to combat the gun violence. That's all I want. Scale of 1 to 10. 1 being low, 10 being high. Just give me your gut reaction. And then the second thing is invariably, when I get about halfway through this thing, somebody will settle on a number. I'm not going to say what the number is, and then from that point on, it's the same, you know, all the way through. So what I want you to do is right now, take a second, think about it, lock it in, and no matter how many people before you say a different number, don't change that number. Again, scale of 1 to 10, I'm just gonna run, really quickly. Law enforcement's efforts to try to combat, the gun violence here in Jefferson County. Miss juror number 1,
You want a number?
yes.
3?
Juror number 2,
We'll say 8.
juror number 3,
8.
4. Oh, 4's not here. 5.
No, I'm here. Where's it?
She's here.
Four.
Oh. Okay. Juror number,
5.
train, Miss juror number 5.
6.
Number 6.
7,
Number 7. 8.
9,
Number 9. Number 10.
6.
11. 12. 8. I got you juror number 13, 8. Number 16.
5.
Number 17.
7.
Number 19.
3.
Number 21.
8.
22.
7.
23.
8.
Mr. Coleman over there. Number 24.
8.
25. 26. 27.
5.
28.
8.
29. 30. 31.
8.
32. 33.
6.
33, you get the prize, the gold star for being the youngest juror we have. You're all of 20 years old. 34. 35. 36. 37.
6,
39. 40. 41.
9.
42.
9.
43.
8.
44.
7.
45.
7.
46. 47. 2. 49.
3.
50. 51. 52. 54. 55. Okay, we're just about there to the end. Does anybody, the judge asked if you know any of us, the participants in this case, but does anyone know Officer Cave Carr with the Port Arthur Police Department? Or think they know them? Think you know them. What about Officer Christopher Garnica with the Port Arthur Police Department? What about a Raymond Adami? I don't think he's from the Jefferson County area. I think he's from somewhere kind of in South Texas. But Raymond Adami, do you think you know that? No hands were raised on that. My last question, or subset of questions, has to do with your personal experiences. Twofold. One, has anyone had a negative experience with law enforcement such that, to the degree that, you know, you kind of have, you'd feel a certain way, perhaps maybe even biased toward the police officer or officers who may be victims in this case. Not just, I'm talking about beyond just getting a speeding ticket, you know, I'm talking about maybe having a really negative experience where you go, you know what, all cops or most cops are bad, that kind of thing. Is there anybody here, and I'm not saying just having that experience, but having that experience and that it will affect your ability to be fair and impartial in this case. Not unlike the judge's example of your home being burglarized and you come in here to find out that this is a burglary case. Anybody on this first row who's had such a negative experience with law enforcement to the extent that it would affect your ability to view this evidence in this case without thinking or going back to that experience? No hands were raised. Second row, same question. No hands. Third row. Juror number, let me get my little chart there. 30, wait. 32, Mr. Gutierrez?
Yes.
Negative experience with law enforcement?
Yes, I had some peace officers put one of my relatives in a coma, passed away about a year later.
And when was that? I'm sorry.
96.
Was it local here?
No, it was a different county in Texas.
Different county, Texas. sorry that that happened,
Yeah.
and thank you for sharing it with me, or with us, Mr. Gutierrez. Anybody else who has had an experience like that, or similar to that, and it would affect your ability to be a fair and impartial juror in this case. Anybody that was it for the third row. Anybody back on the last row back there? Show of hands. I've got your hand being raised, Mr. Gomez. You've had a negative experience with law enforcement?
Yes, sir.
Okay.
Same with my father.
I'm sorry.
Same with my father as well.
Okay. And is it something that you mind briefly sharing with us, or just give me an idea?
That was kind of racially,
We may or may not ask you to come up and visit with us at the bench out of the hearing of the rest of the jury. How long ago did this happen?
with my father's experience was about 6 years ago.
Okay.
My personal experience was 4 years ago.
Thanks, Mr. Gomez. Anybody else on the back row back there? Juror number 54.
I had to change my car because I got pulled over because it's not a car I had. So I ended up buying another. It's not as bad now.
But that's something, that experience is something that has stuck with you, and could possibly be something that you think back on during the course of this trial. Thanks for sharing that, Mr. I appreciate it. And we've talked about your experiences, or lack thereof, with law enforcement. I want to also, lastly, and end with your experience or experiences being a victim of violence, particularly gun violence. I'll give you an example. And again, the same question as it relates to law enforcement experiences. I'm just not talking about, it needs to rise to the level where you won't be able to be fair and impartial is what I'm getting at. In other words, just base your decision or your view of the evidence on what's presented here in the courtroom. That experience, you being a victim, particularly a victim of gun violence, would interfere with your ability to do that. An example would be Mr. Rodriguez, juror number 13. If you were robbed at gunpoint at an ATM, I think that would be pretty traumatic, and it could possibly affect your ability to be fair and impartial. So I just throw that out there as an example. Anybody in the front row who's been a victim of gun violence, such that it would potentially affect your ability to be fair and impartial.
Not gun violence, but a home invasion or something.
You think that would affect your ability?
It's kind of affecting right now.
I understand. Sorry for that. Thank you, Ms. Nobles. Juror number 2.
Not gun violence, but my mother was a police officer,
Yes, sir. I saw that question there.
and she was, during her arrest, she was injured to the point that she went on disability for the rest of her life.
How long ago was that?
I was in college, I was in my 20s, so for about 40 years.
Again, it's a two-part question. I hate that happened, and I'm so sorry that happened, but does it rise to the level that you would, that's something that you would consider or be thinking about during this trial, to the extent to where it will kind of affect how you weigh the evidence and testimony in this trial?
It was long ago, so I don't think.
All right. Thank you, Mr. Medina. Anybody else in the front row, victim of violence, particularly gun violence, and it rises to the level where it would affect your ability to be fair and impartial in this case? Raise your hand on the first row. Anybody on the second row? Same question.
Question.
Yes, ma'am. Juror
So-
number, for the record here, juror number 19.
Yes. So when you say victim, is this gonna be a person that you're related to, or you yourself?
That's a good point, Ms. Rushing, and I neglected to mention that it does not necessarily need to be limited to yourself. If you've got a spouse or a family member or someone that you're close to and they were a victim of violence, particularly gun violence, and it would affect your ability to be fair and impartial, that counts too. Thanks for pointing that out, Ms.
It
Rushing.
will not affect my ability to be fair and impartial, but my brother was killed, fatally shot, over 30 years ago. So, but no.
Rushing. Thanks for prompting me to remember to expand the scope of that that question. Anybody else in the second row, friend, a family member, or even yourself, victim of gun violence, and it would affect your ability to be fair and impartial. You raised your hand, juror number 24, Ms. Lyon.
Yeah, many years ago, I had someone, break in my home and assault me,
Sorry.
but he didn't have a gun, but I did.
Oh, really?
Sorry.
Good for you. But could you just listen to the evidence in this case
Oh, yeah.
and base your verdict based on the evidence in this case and not that previous
Oh,
experience?
absolutely.
Thank you, ma'am. Thanks for sharing that. Appreciate it. Anybody else on the second row? Third row? No hands have been raised until the final row back there. Mr. Hampton, yes, sir. Juror number 54.
Anthony Wilson, shot, and, still taking care of his mother. Cook behind that.
Anthony Wilson, and
Yeah,
he
not
was,
to hear him, well,
and how was is he related to you? Or
he was like a son to me, in a way.
how long ago was it?
And, 4 years ago.
Would affect your ability to,
Yeah, I haven't gotten over that, because she's still dealing with it because of holidays, without her son. So I just go over there now.
thank you, Mr. Hampton, I appreciate it. And thank you all for sharing and engaging me with your responses in this case. Is there anything else that I've overlooked? You're sitting there thinking, my goodness, if only he'd asked me this, I would have given him an earful. If only he would have said X, Y, Z, I would have really given him my opinion. All right. I, again, thank you on behalf of the DA's office, the community, and the victims in this case, and I look forward to presenting my case to the 12 of you who are selected.
Thank you, Mr. Coleman. Mr. Matuska, you may proceed.
Thank you, Your Honor. Mr. Coleman, Mr. Hopper. All right, gentlemen, I'm just gonna turn on the computer here, just give me 1 minute.
And I'll tell you what, while you're doing that, let's go ahead. I'm gonna let them take a quick break. I know sometimes people are thinking, oh gosh, we have to go through another one. And so what we're gonna do is take just a very quick 10-minute bathroom break. Please, when you take your break, don't talk about anything that has to do with the case or the type of case or anything like that. Just run to the bathroom, come back. There are restrooms at the end when you walk out of my courtroom, at the end of the lobby down on this floor, also on the 3rd floor and the 1st floor. So you can kind of disperse that way. And then there's some others to the left on this floor, just in between this courthouse and the other one that's attached. Again, if y'all just take about 10 minutes, it's 2:30. We'll try to get started at 2:40. Gather right back outside and the bailiff will get you in at the appropriate time. Thank you. Y'all are all excused.
They felt so strongly about it, they created this document for us. Speak freely, they'll punish you for that. Prevent you from going to your church, shut down unfavorable news. Take your guns, unreasonable search, imprison you, take your liberty. Deny you due process of law, force you to answer questions, deny you a legal advocate. Excessive bail, excessive fine, and cruel and unusual punishment. How many of us have really thought about that? Ms. Purdy?
Thinking about it, I don't think about it too much.
It's kind of shocking when you actually consider what they were going through, isn't it?
Yeah.
Do you agree or disagree with them for creating this document for the week?
Absolutely.
Why is that?
Like you're talking about the Bill of Rights,
Mhm.
so that we have things that protect us from tyrannical governments like they did over the years.
Yes, we don't go back to there, do we?
Right.
Ever. Thank you, Ms. Purdy. Mr. Hope, how do you feel about the Bill of Rights? How do you feel about these? You don't know? Okay, that's fine. Well, let's say the government tells you that they represent the people and the government. How does that make you feel, Ms. Rush?
Government lawyers are representing people
Any
and
government
government.
agents.
I don't see how that can be fair and just, but,
What's that?
well, the government lawyers are representing government people. I would think that they would be more biased for them than for the people.
Thank you. Mr. Richmond, how do you feel about that?
Actually, I believe that's a true statement. I mean, I think, they protect, the government does protect people, I mean, lawyers.
Okay, tell me more about that. Why do you feel that way?
I mean, that's their job. Their job is to protect, people, prosecute criminals.
Okay, so what if the IRS came to your door? And they said, we're here to protect you and we're here to take your money.
And they don't get due process, right?
Yeah.
Got the IRS lawyer today.
I'm so sorry. I'm so sorry. You want to come up here later, we'll get you excused. Ms. Richmond, thank you for sharing that. But you see my point. I see your point. And that's very confusing sometimes. Mr. Durham, can you see how that could become confusing in a criminal case? Tell me more about that.
You know, I guess in a lot of positions, people can abuse their power. So what you're assigned to do may not be in your actions.
Thank you for sharing that. Moving on to my role as a defender. Now, what exactly is my role, Mr. Coleman, in this whole entire process? Can't answer. Tell me why. I'm just asking you why. There's not a reason why you can't? Okay. And that's okay if you guys can't say anything. But as Mr. Coleman said earlier, I'm going to ask you why you can't, to be fair. Mr. Coleman, do you not want me to ask you any questions? Do you not want me to ask you any questions? Yeah. Okay. I respect that, and I won't ask you any more questions. Ms. Lyon, could you tell me what my role is here?
To make sure the government does their job also.
Do you feel like the defender is an important role in a trial?
Yeah.
Why is that?
The defender is an important
Yes.
role.
Do you feel like it's necessary to have a defender and a government lawyer at the same time? Would our system work?
Yeah, that's checks and balances, I guess.
Checks and balances. Thank you. Ms. Hodges, how about you? How do you feel about it?
Yes, in order to have a trial, you have to be defended, I mean, someone has to defend the person who is, you're innocent to prove guilty. So there has to be a defense in that situation, and the government is going to take the side of, sometimes they actually charge the person without even anybody pressing charges. The government can just jump in there and do it. So then if you didn't have a defender, someone could be put in jail and no one knows about it.
Well said. And you don't have to have a lawyer, do you? You just have a right to one.
Right, or you,
So could you represent yourself if you wanted to?
yes,
Would you do that?
depending on how well I knew the law.
Okay. Does it sound scary, or do you feel like
Yes,
confident you
it's
can
pretty
do it?
scary, but if you knew the law, you could defend yourself.
You could, and I've seen it done, and judges seen it done many times too.
It's a bad idea.
I know, right? It doesn't make you look good.
Don't do it.
Thank you, Ms. Hodges. It is an honor that I do this job because I, same as y'all, have been created in this document by our founding fathers. They created my job just like they created y'all's job. For the people. Now, Ms. Boyd, can I ask you, does it matter which table the government lawyers sit on?
The doesn't matter to me which.
Doesn't have a sign on it, does it?
No.
No. Is one table further back than the other? No? Any advantage to having one table over the other that you can see? No. This is our courtroom. This is a general courtroom, but this is how our courtrooms in the United States look compared to those other courtrooms that we just saw earlier. Because of the presumption of innocence. Presumption of innocence, as we talked about earlier, is the only lawful authority needed for you to elect a fellow American citizen not guilty. That's why earlier when the judge asked you, guilty, not, and said not guilty. But this is what we call presumption of innocence. Maybe you've heard on TV or even in a book, innocent until proven guilty, right? We've all kind of heard that. Mr. Clark, you heard that? Mr. Clark?
Yes.
You heard that? Where'd you hear that at?
Well, in a courthouse,
In the courthouse?
television, different, but, my experience with the law.
Yes, sir. Did y'all know it's actually unless? Does that make sense? Ms. Castillo, nobody asked you anything yet, have they? Yeah, okay. I missed it. Does that make sense to you?
The innocent until proven guilty.
Unless, yes.
Yes, I guess we're just so used to hearing the until.
Until, exactly. Now, anybody here have any legal training experience? Anybody go to law school? Sometimes we have lawyers and judges. Anybody worked for a law firm or even government agency? No? Okay. Anybody besides Ms. Lanning work here, Jefferson County, at the courthouse or any agency in council? No? Okay. Probation officers, anything like that? Okay. Juvenile probation? Yes, ma'am. Anybody married to each other in here? Recently, I had a 6-person jury and we had 2 married couples on the opposite end. That surprised me. We have a very important case here, as you've heard, involving aggravated assault against the public servant. Now, this is what the government has to prove to you. Intentionally and knowingly threaten a public servant, imminent bodily injury, used or exhibited a deadly weapon during the commission of an assault, and the defendant knew that the complaint was a public servant lawfully discharging an official duty. That's a mouthful. But those are all important elements that have to be proven in this case, beyond a reasonable doubt. Now, can I see a show of hands of anybody who's either law enforcement or who has a close family or friend in law enforcement? A lot of us, and I've seen a lot of people with cards here on who those exact members of your family and your friends are. Anybody see these flags? Ms. Garcia, what is this flag?
The kind of like that to protect the blue.
Protect the blue, which is protect
It's police officer.
police. It's a support of police officers, correct?
Yeah.
This is a very common thing that we see around here. Anybody have a question about this flag? Okay. Now I have a question. What if this was the gallery and you were the jury? How would you feel, Ms. Garcia?
I think that I would kind of feel overwhelmed because again, it's all police officers and that depending on the case, it's kind of like you feel like you're pressured into one way of thinking or another.
And how would that make you feel?
Uncomfortable.
Uncomfortable. Okay. Thank you. Mrs. Edwards, how would that make you feel? Same reason or different?
Same.
Ms. Brown?
Wouldn't make me feel uncomfortable,
Okay, why is that?
because I would just be focused on the information that's being presented, and just, this other stuff would be like noise to me.
You wouldn't even pay attention to who's out here. So, thank you for sharing that. And Mr. Rodriguez,
Same thing.
just focused, right? Okay, thank you. Now, the judge made a very good point earlier that we don't define beyond a reasonable doubt. Now, I want to go through this exercise, and I do it in every trial, because we do define what's under it. Now, we have legal standards throughout the courthouse. Now, I narrow that down to 5 main legal standards in a criminal case. The first one is a reasonable suspicion. Now, who's had a traffic ticket or any reason pulled over for something small? Anybody? A lot of us. Officers just need a very basic level to do that, to pull you over and to talk to you. This is a minimum level of proof. It's specific reasons, but it can't just be a hunch. Does that make sense, Ms. Henry?
I'm sorry, what was the
Does it make sense that it can't just be a mere hunch?
question?
Why is that?
Because they have to prove reasonable doubt.
Well, they have to just have some reason, right?
Right,
You don't want people just randomly pulling you over for no reason, right?
that's correct.
And officers are human, right? So, do you agree or disagree that it's just a tiny bit, but it's gotta be something? Does that make sense to you?
It gotta be something.
Okay. Mr. Ho, do you agree with that? Maybe? Or do you think it's okay just for a mere hunch?
I think it's okay.
Okay. Now, to actually arrest you and search you, we go up a little bit. This is more than reasonable suspicion. But it's not 50%. If any of you have been on a civil jury down the hall, you may have heard preponderance of the evidence. You may have heard of just dipping the scales a little bit. We've all seen the scales. 1% more than 50. We have defined this in the civil court. Has anyone heard of this? Clear and convincing evidence. Ms. Pacheco, you ever heard of this one? No? Ms. Simmons?
No.
No? Mr. Gutierrez?
Yeah, I believe so.
You have? You know why I put this picture up?
Yep.
Tell me why.
I mean, it's just, yeah, reasonable proof, is it clear?
Take your children.
Yeah.
That's scary, isn't it?
Yes.
Now, in order to do that, we have defined that as clear and convincing evidence. But we've said that beyond a reasonable doubt, we're not going to define. We're going to leave it up to the jury, up to y'all. But we're not going to define it. We're only going to define what's under it. Does that make sense to you?
Yes, I believe that.
Okay. Mr. Wright, what about you? Does that make sense to you? Why is that?
You gotta listen to both sides to determine, which way it's gonna go.
And do you think to take an American's freedom and liberty, that's the appropriate level, above those levels we talked about?
Depends on what you get. That's a possibility. You gotta, like I said, you gotta listen to all the evidence to decide how far you take it. If they're gonna do it or not.
Yes, sir. Thank you. And, is it Ms. Martinez? How do you feel about that?
I would say as well.
That it's appropriate, or you just have to hear the evidence?
To get the evidence.
Okay. Proof beyond reasonable doubt requires the government exclude all reasonable doubt, okay? It's beyond a reasonable doubt in your mind. It's each and every element that we went over earlier. Is that common sense?
common sense would, in all reasonable doubt, if you prove to that point, common sense all points one direction. Gravity, you're also just gonna fall.
Common
It's
sense.
gravity fail.
Okay, thank you. Mr. Rodriguez, common sense?
Common sense.
Okay. Is it Ms. James? David? Common sense?
Are you asking about the previous question?
Yeah, it's beyond a reasonable doubt, common sense. Yes, okay. Thank you. Ms. Gilbert? Has anyone been to Walmart parking lot lately? There's a lot of common sense going on there, right? Someone's shaking their head in the back. Is it, Ford?
Yes.
You don't think so?
Walmart parking lot is crazy, there is no common.
You might appreciate this meme I found. Walmart parking lot is one of the most dangerous places in the United States. You agree wholeheartedly on that one, okay? Mr. Jim, have you been to Walmart lately? Yeah.
Yes, I have.
It's not fun, is it? Park it at least.
That's why I take that truck and park it in the next park.
That's smart. You go to Academy parking
I
lot.
don't mind walking. Whiskey dents just don't look good on that board.
Yes. Now, I bring this up because if it comes down to just use your common sense. Ms. White, do you think that's beyond reasonable doubt in your mind? Excluding reasonable doubt in your mind?
What common sense?
Mm-hmm. Or you think it's more?
That's two separate.
Two separate things, okay. Mr. Clark, how about you? Okay. And, is it Helen? Helen, Miss Helen, how do you feel about that? You agree or disagree? Two different? Okay. Is it Ricky? Miss Ricky? Rivette. Agree or disagree?
Honestly, though, common sense. I see both sides, or to be honest with you.
That's fine. That's why we're here.
Because you could use common sense to prove beyond a reasonable doubt. But common sense and beyond reasonable doubt could be used.
Okay. So it's okay to use common sense, right? But you're a little hesitant on a break there. Is that what you're saying? Okay. Anyone else have a feeling about that? Because this always comes up in trial. All right. Oh,
I think they're two.
is it Ms. Prince?
Yeah, I think
Okay.
it's common sense, I think there's facts. Everybody don't have common sense, it's pretty big. And sometimes their common sense doesn't make sense to you, that it is common sense,
So,
so that's just my opinion.
okay. Thank you for sharing that. Ms. Ford?
No, I was thinking that, like, you can, like, see, somebody standing over a body with bloody hands. You don't know if that's a murderer or a nurse trying to save their life. And somebody could just go, oh, well, they're standing over them with bloody hands, that's common sense, they gotta have done it.
So that's why the presumption of innocence lasts throughout the whole trial. Until we get together as a jury and we decide to vote and talk. We've listened to the evidence, right? All of it. Considered everything and weighed the credibility of certain things, right? Okay, is that what you're trying to say?
Yeah.
Yes, ma'am, thank you. Now, we talked a little bit about the fifth, well, we've heard the fifth. Everybody knows what the fifth is, right? Michael can sit, he can listen, he can do nothing, present no evidence, and invoke his right not to testify and just remain silent. Now, Ms. Richter, how do you feel about that?
That's not a problem with that. I mean, the state's supposed to prove the case.
Okay, thank you, Ms. Richter. Ms. Richter?
I think that is, I mean, it's his guaranteed right, according to the Bill of Rights. And so, he has his reasons. We have to respect that. That puts the burden on you, and that's your job.
Puts a burden on me.
Well, you have to defend him because it's your job to defend him.
But who has the burden in a criminal case?
The state.
State, okay.
Yeah,
I'm just asking.
of course. But
Maybe I need to do some different things.
Right. That scale that justice holds is
Yes, ma'am.
this. So, yes.
Thank you, Mr. Wright. How do you feel about that? Okay.
That's his choice if he wants to speak up for himself, or just let the evidence provided.
Yes, sir. Well, why would the founding fathers even put it in there? First place.
Could be somebody that's nervous in front of people, he's speaking in front of people, he's saying this, speak for something. So, I mean, I recall the entire, occurrence or whatever.
There could be a dozen reasons, right? We're all different. We all have education. It may be hard to sit in a chair up here and let two lawyers, 20 years plus, question you, right? It's kind of intimidating to some degree. Is that how you feel? Okay. And everybody, well, I'm just asking you. Okay. Now, we just kind of went over some innocent reasons, but is there anything that anyone wants to add to that, of any reason that would be an innocent reason not to do that? Okay. Now, Ms. Coleman touched on this a little bit about CSI stuff on TV. Yeah, we hear it, but it's 2025 now. So,
Six.
I need to update that slide. So, at this point in 2026, is there anything that's so unreasonable in your mind that you feel like in Jefferson County that we shouldn't hear? What about video evidence? Anybody feel like that, Ms. Albritton? Video evidence this day and age?
Well, video evidence is evidence, so.
Fingerprint evidence, is that something you think is?
You've got proof that that is their fingerprints.
In this type of case, what do you think would be helpful to you?
Well, just to see the details, to know the details, and actually see it, if there is a video.
Yes, ma'am. And I expect Mr. Coleman will present evidence of nature that you expect. It's not just testimony of witnesses. But what about those witnesses? Ms. Albritton, how do you feel about weighing the credibility of a person's testimony?
Well, you know, there's been a lot of, there's so much corruption in the world that there's been a lot of people that have actually they've said that they will tell the truth, the whole truth, the whole truth, but yet they have not. So, I don't know, I have to just hear it, look at their face.
And just weigh that according to the questions and the answers, right?
Mr. Matuska, you've got about 7 minutes or so.
Thank you, Ruth. Anyone know his lawyers? Very nice.
Some people don't know. Who's the judge?
Huh?
I said, who's the judge?
Oh, I don't know. You know? Okay. You had me there. I should have done that. How about eyewitness testimony, Ms. Castillo?
So that could be like anybody witnessing?
Any bystander there? How do you feel about that?
I feel like somebody's perspective can change because they're in shock, so they can see one thing with another, or vice versa. But the cameras from anywhere, like a local place, it definitely helps testimony. But sometimes they help, sometimes they don't.
Well said. Thank you. Ms. Garcia, how about you?
I think that testimony from a bystander can be a little bit they might remember something else. So the memory is a process of reconstructing something from the past, and it can obviously not be perfect. It's not like a video recording that's perfect, because individuals basically are trying to reconstruct something that happened in the past.
Okay, very well said. And, Mr. Tanner, how about expert witnesses? Specialists?
I've never dealt with, other than watching on TV,
Mhm.
that's almost,
Well, I think that's enough, because you listen to them on TV, right?
also Law and Order.
Yeah. And what makes you pay attention and not pay attention to that?
Their level of expertise, the facts that they can present, the knowledge that they bring to the court.
Have you ever seen an episode where it was two experts competing against each other? No, that happens sometimes. So if that's the situation, that would be something different, right? And you've seen, okay. Now what about accomplice, Mr. Purdy? You ever heard of that? How do you feel about that?
As far as testimony from it?
Yes, sir. Testimony from co-defendant, same charge.
Probably depends on what they're facing, as to, you know, hey, we're gonna, if you testify against him, then we'll give you leniency, or we'll give you, you know, we'll let you go.
Is that something you would weigh in your mind?
In my mind, I would think about it.
Okay. Thank you for sharing that. Mr. Ho, what would you weigh in your mind? I don't know. Okay. Thank you. Ms. Nobles.
Their credibility.
Credibility. And what factors would you like to see? Okay. Thank you. Would anyone expect also equal investigations? Ms. Edwards,
Yes,
why is that?
because then you have, because they can tell you anything, and you expect you to believe it, but if they have equal, both they investigate, then you have basis to see if they're telling the truth.
Yes, ma'am. Well said. Thank you. Ms. Brown.
Yes, I think that it would be good to have equal investigation, because you can have both sides of the story, and you can more or less see if pans out or not.
Yes, ma'am. Mr. Rodriguez?
Depends on that person. Like, one person can say one thing and the other can say another.
Okay,
Not compare testimony.
that's a good point too. Thank you. Ms. Tanner, how about you? How do you feel about that? Yes, sir.
I think it should be same effort, police effort or investigative efforts would be mandatory for both sides. For the same charge, equal investigation, considerations
Why would that be important to you?
to make sure both people get a fair shake.
Yes, sir. Okay, thank you. I'm not going to go over this again, because I think Ms. Coleman did a good job. Is there anything anyone feels like they wanted to tell us about that Mr. Coleman didn't touch upon? And if there's anything that you feel is personal to you, I would encourage you to tell the bailiff as soon as we break, and you'll have an opportunity. You can ask to come up privately, okay? Mr. Tanner, you've heard what kind of charge this is. You've heard the range of punishment, 5 to 99. Can you consider 5 years for what you heard?
Heard the evidence,
Okay.
or the presentation.
Okay. So you could not consider the full range of punishment, or you could, without knowing anything.
We don't know. Don't know until you know.
Okay. Ms. Clark. You do, yes. You want to hear the evidence? Right. Okay. Ms. White.
Yes, considering the range, I would be open to
considering the range depending on whatever.
Before we told you a single fact.
My mind is not made up. I don't have a certain range of.
But that's not what I'm asking. We haven't even gone across the starting line yet. I'm asking you to consider the full range of the law.
Can I consider the full range of the law? Yes.
Yes, okay.
Yes.
Why is that?
Because that's the opportunity that the defendant is given, and that is the law.
Yes, ma'am. Thank you. Ms. Hodges, how about you?
The severity of the injuries, and if you say 5 years, and a person could be crippled, we don't know the severity.
You don't know any
Whatever
facts.
happened, it could be no injuries, so without that, you can't really make that decision on, the severity of punishment. It has to be
You want to know more about the harm?
to have equal punishment, or someone.
Yes, ma'am.
That's what-
Ms. Lyon.
Ask me again.
Can you consider the full range of punishment, even 5 years, without knowing a fact?
Oh, without knowing that. Want to know the facts?
Yes, ma'am. Ms. Coleman, I'm not going to ask you a question. Mr. Durham, how about you?
With the facts, I could definitely consider that range.
Okay, but not right now?
Correct.
All right. Okay, as I stated, not all of you are going to be on the jury. Very few actually considering we're only going to have 12 on the jury, and maybe an alternate or two. So, it's very important that when we participate in this, we listen to each other, we have different experiences, we have different educations. And anybody who's been on a jury before, can I see a show of hands that's participated in a jury, knows that this is group work, right? Ms. Prince, how was that experience for you?
It was difficult. It was a difficult experience. It took a lot of group collaboration. It was difficult. It wasn't an easy choice to decide when you're going to
I'm glad you pointed that. No one ever says it's easy.
decide for someone's life. It's never easy.
Yes, ma'am. Who else raised their hand up here? Ms. Brown?
It was a long trial and it was difficult. But we did come to some conclusion when we weighed the evidence and we went back and forth with the different aspects of it. And we came to a unanimous conclusion.
Thank you. Anyone else? Mr. Tanner?
It's education. After the evidence we were presented, we found these are DUI that we found guilty as charged.
Considered everything, talked about it?
It was very educational.
Yes, sir. Thank you. Same row right here. Anyone else raise their hand? Mr. Durham? How was that experience for you?
Much the same as everybody else, it was testing at times, but, based it on the evidence, come to a decision.
Yes, sir. The second row here? Anyone? No? Okay, did I miss anyone in the first row here? Okay, third row? Okay, Miss, is it Richter?
It was difficult. I was on a murder jury. I was on one for termination of criminal rights. I was on the Jefferson County grand jury. And they're all difficult. You have your reasons for thinking as you think, and then you come together with 11 other people and you see things, so many different viewpoints, and it does take a lot of adjustment and horse trading to get there in the end. And it does, you have to make up your mind to be open and to do the job you're charged with doing. So, it's very much group work.
Well said, and you all are here again, so I expect that you all are willing to participate in that process one more time. But if not, let us know, please. And I just ask that you vote with your individual conscience, and you work with everybody on that jury, because it has to be unanimous, meaning every single one of you has to agree. Any questions from anyone? I'll wrap up. Okay, look forward to trying the case, for those of you that get on jury. Thank you.
Thank you, Mr. Matuska. And so, ladies and gentlemen, I'm going to ask if for just a minute, you'll remain very quiet. I'm going to have the attorneys come up, go through that list of the ones that I made notations that we might need to visit with. And then if I don't call your name on that list, you can let me know if there's something you need to come back in and visit with us about. Mr. Coleman, Mr. Matuska, Mr. Hoffpower.